Welcome to the Legacy Leaders Podcast. Are you doing the best for your client to help them create their legacy? Are you creating a plan that goes far beyond finances to help people ensure that it becomes the driving force behind all decisions? On this podcast, hosts Katie Beth Hand and Stan Miller will help you with growing your practice and your clients' peace of mind. Together, they bring the best and brightest minds to share with you how to help your clients develop their best legacy. And now, here are your hosts, Katie Beth and Stan.
Okay, guys, thank you so much for joining us for the podcast. Today, I have a very special guest. We are going to be talking about estate planning and legacy planning and all that good stuff, the things that we need to think about when we are adulting in this day and age. So without further ado, I want to introduce my special guest, Ronald Schirtzer. All right, Ronald, do me a favor, introduce yourself to the people. Let us know a little bit about you.
Sure, Tanisha. First of all, call me Ron. And I am a commercial litigator who's been practicing coming up on 39 years. And I'd say I'd spend about 20% of my time these days working in the areas of trust and estates litigation. I don't generally provide wills or trusts. I will occasionally look at them and provide comments, but it's not my specialty. But my specialty is in the litigation area where things go wrong. And being in the litigation area where things go wrong, I occasionally can have some good advice as to how to avoid ever having to need my services down the road.
So you are hitting the nail on the head where I wanted to get to, because I think a lot of times people think that having certain things in place legally just automatically covers them. But the reality is, if they haven't spoken with someone like you, there's often a lot of gaps in there. And so I would love to just jump right in, obviously protecting confidentiality of clients, things like that. I want you to dive a little bit more into the side of the commercial litigation and some of the challenges that people tend to have in that space. And then we'll get to how to avoid, how to make them go better.
So the typical trust and estates litigation occurs where there are competing either beneficiaries, family members sometimes will be fighting with one another, or in some instances there are charitable elements of a will or a trust that the family wasn't quite either told about up front or isn't signing off on up front. And so once someone has passed and it's time to divvy up their estate, it doesn't just happen automatically, and it doesn't necessarily happen exactly the way that the person who left their will or left their trust instructions want it to happen, because the remaining family members and other people who have claims on the estate will sometimes challenge the validity of those documents, challenge the mental capacity of the person who wrote the will. And then sometimes there's fighting with one another, often with second wives or husbands, and blended families where there's questionable activity as to how a will was procured in the final days of somebody's life. So those are the circumstances that give rise to trust and estate challenges.
So that is a lot to unpack, right? So we've seen a lot of these types of, maybe not everybody has seen, but I'm sure you and I keep an eye on when these things are happening, particularly in the public spotlight, things like that, major situations. But I want to talk a little bit deeper about the challenging of validity, right? And so in your experience, most people may come to you and maybe they have those wills in place. But then when it comes to challenging the validity, is it because, well, you tell me, what are the grounds that they're even able to challenge the validity of something when they have this legal document was drafted that was supposed to state how things are going to go? How are they able to do that?
The primary issue that usually comes up is whether the person who signed the will was in fact in full possession of their faculties when he or she signed the will. So here's a typical circumstance. Individual is married for extended period of time, could be a first marriage, could be a second marriage. And then the spouse passes away. And between the time the spouse passes away and that individual passes away, they either meet somebody new who they may or may not get married to, or they come under the influence of various people who undertake questionable contributions to organizations, to charities. And so usually it's the children of the person who is now the second spouse who passed away, who are coming in and saying, wait a minute, this is not what my father or my mother really intended. They were either not in full possession of their faculties when they wrote this, or they were being unduly influenced by either a new spouse or a new boyfriend or girlfriend or someone along that way. So that's where those issues usually arise.
So what's the recourse? Obviously, if you're in that situation, you feel like I need to challenge this. I know my mother, I know my father would have never done this type of thing. How does that work? There's the legal side, and then there's the relationship side, the family dynamics.
Right. So when you've gotten to the point where you're ready to potentially challenge somebody's will, the relationship side has usually devolved at that point, and the parties are no longer putting up any pretense of trying to get along with one another. So then the question becomes, how do you prove that somebody didn't have their mental capacity? And you prove it through a variety of medical evidence and anecdotal evidence from people who have interacted with the person around the time that they signed the will or they executed the trust you're attempting to probate after the fact. So I'll give you, without disclosing any client confidences, if you have somebody who had exhibited somewhat erratic behavior, you can obtain all of the medical files that show their medical treatments that they received. And then you would hire something called a psychiatrist or a forensic psychologist. And they essentially review the medical records. They interview people who interacted with the deceased and try and come up with their expert opinion on whether or not that person had sufficient testamentary capacity at the time that they wrote the will or signed the will or signed the trust documents. And then you present it to a court, either a judge or in some instances a jury, and the jury is ultimately going to decide whether or not that person did in fact have their capacity. The other thing you do is you look at, was there a prior will and were there changes? And if there are changes, what's the rationale behind the changes? Is that something that seems likely that the person would have done, or is it something that has a little bit of an odor of somebody's pushing their hands and making them or suggesting to them that things that aren't necessarily the case? And it's a very, very emotional, heart-wrenching process in not many instances because, for example, when children become estranged from their parents because of a new spouse or because of a new girlfriend or boyfriend, those are very hard situations for them to understand. We all live our daily lives, and it'd be great if we could devote a sufficient amount of time to be with our parents on a regular basis, but often we're in different parts of the country and interaction is limited. And then you suddenly see strange changes in the relationship that accompany this new love interest. And that's where things start to go south.
Yeah, I think that's one of the toughest things, especially as an adult watching your adult parents. Obviously, life changes and things happen, and other parents and spouses move on in one way or the other. And
Mhm.
so navigating that is very much complex. And then when you add in the legal aspects and the hurt that people are experiencing when they're losing someone, it becomes almost an emotional snowball, right?
It does. And
And
often you've got to make the decision after the fact from your own mental health standpoint. Even
Mhm.
if you're convinced that this is something that your parent would never have done under normal circumstances where they weren't subject to undue influence or even worse mistreatment that leads to these type of decisions in some instances, is how is that going to affect you? Are you, willing to relive all of this and go through the expense and the time and the effort of litigation, or is it better for you, to just let it go
right.
and move on with your life and try and remember your loved one as best you can before these changes occurred?
So, and with the clientele that you service, because I don't want to put words in your mouth. So, what would you say? What is the type of client that you're most often working with prior to something happening? Maybe helping to put those trust and other things in place, estate planning. What's the type of client that you're typically working with on that side? And then obviously after that.
So I normally get involved in the litigation phase. So a client is typically who's come to me would typically be the child of someone, an elderly person, who believes that their parent is being unduly influenced by somebody or just no longer in full possession of their faculties, and they need to take action to protect that person from being taken advantage of.
Mm.
Often that they come to me after the fact. The parent has already passed away, and now they're looking to challenge the questionable estate document that they think was the subject of undue influence. On
Mhm.
occasion, I'll represent institutions when they're subject to challenges related to charitable donations. I've done that type of work where it's usually pretty wealthy individuals have made some significant charitable contributions as part of their estate, and their family members aren't quite as charitably inclined
Right.
as they might be. And so they will make a similar challenge based on undue influence or based on lack of mental capacity. And then it's litigated in a much the same way, but it's a very different dynamic of the finger pointing going both ways on that. Usually, at least the charities that I've represented are pretty reputable, well-known charities. And so it's hard to convince anybody that that charity did anything improper to create that gift. Usually it's a question of whether or not the person just had sufficient mental capacity. And regardless, they're not suggesting that the charity is somehow at fault for some of the decisions. They're just questioning whether the person was sufficiently competent to make that type of decision.
Right.
Whereas when you're challenging a will or a trust that takes your parents' estate and gives the bulk of it, if not all of it, to someone they've known for 2 years prior to their passing, that's a very different dynamic and a very different set of circumstances.
So, in that vein, right, I am sure you've seen quite a bit over your 30 plus years in the industry.
Mm-hmm.
So, what would you say is one of your most memorable kind of litigation scenarios that is actually quite commonplace, but it's
All right, so I'm gonna change the names to protect them, not necessarily so
yes,
innocent,
please. Yes, yes, please.
and just give generalities rather than
Yes.
the actual specifics of this case. But there are circumstances where the decedent turns out to be one of several similarly situated decedents with the same new spouse and the same or very similar set of circumstances as to how this person comes into the decedent's life shortly before the end of the decedent's life has the decedent essentially disinherit their children and leave everything to the new spouse. And then after the first one, they go on to the second one. And then after the second one, they go on to the third one. By the time you get to be the third one, it's a lot easier to convince people that, okay, this is a pattern. And here's the strange things. You can show that the exact same things are happening in different family circumstances. And so it is very unlikely that all of the children of the various decedents were all money grubbing, uncaring people who had no interest in protecting their parents, but just were after their money. Mm-hmm. You can maybe convince somebody that the first time, but convincing them that the second and the third time, when they get the children of the first and the second people to come and testify on your behalf, that becomes a lot easier case.
Right.
So it's almost, there was a movie years ago called The Black Widow that had a similar theme. And it's almost that type of circumstance that you see occurring. So that's probably the most salacious of the circumstances I've dealt with in my career. Sometimes it's just children fighting over who gets the dishes, who gets the 64 Mustang that their father treated like a baby for all the years. And it's not, a lot of times people don't leave particularly instructive decisions on how they want that stuff divided. People get busy during their day-to-day lives. Sometimes people die unexpectedly and haven't gotten around to getting into that type of detail. And I think it was Thomas Jefferson who once said that you never truly know a man until you've litigated an estate with him.
A whole lot starts to come out in those scenarios.
Yeah. Money and emotions will make people do crazy things. So the three worst areas for practicing law in terms of the emotional toll it takes on the litigants and the lawyers are divorce, trust and estates, and employment law. Probably in that order. And I, in my practice, have worked in all three of those areas. And it's always the distinction between that type of litigation and a personal injury litigation is, you don't really have a relationship with the person who hits you with their car. And then in general, big business litigation, it's as Michael Corleone would say, it's business, it's not personal. It can be very contentious, it can be very expensive and nasty, but it's business. And you're two sides that really don't have any type of emotional connection with one another. You're just fighting over a business deal gone bad. But when you deal with divorce and you deal with trust and estates and you deal with employment, you're dealing with people who have had a connection for an extended period of time. And it's not business anymore. It's emotional. And it becomes a lot more contentious and a lot more gut-wrenching.
So obviously the family is going through and they have their own emotions that they're dealing with all these things. And then because of the fact that you have to get involved with this family. Have to get to know who's this person, and really from the outside looking in, figure out the dynamics. What were the dynamics? What were the true dynamics? Despite what you're being told, what do you see? Mm-hmm. How do you, in that space, even protect yourself? Because that energy of that can be tremendous to take on. So how do you personally protect yourself?
So a good lawyer always has to maintain a certain level of detachment, because if you become too emotionally involved, you lose your objectivity, which is part of the reason you're being retained, to make a reasonable and rational assessment of what's the likelihood of success, where is this going to wind up, and what's it going to take us to get there, and am I going to wind up spending more money litigating this case than I'm ever going to get out of it from a success at the end of the day. Now, in trust and estates litigation, there is an opportunity in circumstances for the court to award fees to the prevailing party from the share of the estate that would otherwise go to the non-prevailing party. But that's not guaranteed. That's within the discretion of the court. And like all other litigation, the majority of trust and estate litigation ultimately winds up getting resolved by settlement. The parties, the risk factor and the cost factor is too much, and the parties wind up coming to a Solomon-like agreement of somehow splitting the baby and moving forward.
Okay, fair enough. So if you guys are listening out there, that means that when you have a good attorney, they care enough to ask you all the tough questions, but they also care enough to remain objective so that they don't get so caught up in the emotion that they can't do their job. So, because I think that's something that sometimes people will look at, they will see the detachment that attorneys have sometimes and think that it's for lack of caring. They misread it. And so I think that's important to highlight. There's a level of detachment that you do need the attorney to have in order to do what you hired them to do.
Yeah. And an observant client can recognize the distance between an attorney who's just churning files and not really paying close attention to what's going on, and an attorney who is maintaining a certain degree of distance and objectivity for the purposes of allowing them to accurately assess the case and not get too emotionally involved. Look, lawyers are a competitive breed, and we all love to win. But sometimes winning is not necessarily the be all and end all of representing your client. Sometimes your client is better represented by making an assessment early in the case and coming to a reasonable resolution where both sides give in a little, but you've spared them a significant amount of heartache, a significant amount of expenditure that only is going to go ultimately to the pocket of the lawyers.
Just out of curiosity, because of the intensity that can come with this, and because of the experience you've had over the years, why is it that this is the particular area, the commercial litigation, that you settled on? What puts you on this particular path?
With the trust and estates litigation, I've had some personal dealings with trust and estate matters and family matters. And so I'm a little more attuned to the impact that has, and I'm a little more willing to spend the time and effort to assist other people in areas where I've personally experienced some of these breakdowns of the family unit. The other stuff's kind of happenstance. When I was a young lawyer, my first trust and estates case was related to a charity. And I was litigating a variety of different types of commercial disputes. And I just got that assignment in the law firm that I was in at the time and developed an expertise in it. And it's gone on from there. Same thing with the employment law stuff. I sort of happenstanced into it along the way.
As life typically happens, right?
Mm-hmm.
So I'm just curious. So we talked a little bit about kind of things that have gone wrong and how crazy it can get in your particular example. So what would your advice be to someone who's listening right now and saying, I don't want my children or my new spouse or whomever to have to deal with going through the, if you will, drama that could potentially happen? What are their best ways to try to not have those things happen?
So the first thing you need to do is you need to sit down with your existing spouse, assuming that you all are married and have been for a while. And you need to talk about how you want your estate handled. And that's true whether it's your first marriage or your second marriage or whatever. You have to make a decision as to, okay, how do I want to divide when I'm gone? What do I want to happen to my assets? And then you need to sit down with a competent trust and estates lawyer who prepares wills and prepares trusts, and go over how you want that stuff to occur. Now, one of the biggest issues that ultimately leads to problems that I see is that people are a little afraid of making a commitment to something called a irrevocable trust. They want to have control over their assets. They don't want to be dependent on somebody else making those decisions. But when that happens, when you only have revocable trusts, and usually what will happen is you sit down with a lawyer and they create a revocable trust. And the idea is that the money all goes, or the assets all go into the revocable trust on one person's demise. And then the remaining spouse can use the assets from that trust while they're alive as they see fit. And then it'll go to the children or whomever when that ends. If you make that second trust revocable, that's where the problems come, because that's when somebody can come in and convince the remaining spouse that those kids of yours, they don't care about you. They're not here to take care of you. I'm here with you all the time. You should leave everything to me. And so you get a couple that have been married for 40, 50 years that have kids together, have built up a significant estate. One spouse dies, and then they're an elderly person who's lonely, who may not be in full possession of their mental faculties. And there's an entire cottage industry that preys on that. And if your trust is revocable at that point, you're allowed to do with it whatever you want. So trust, for the most part, even if you have kids that you don't think you can trust, find one of those kids that you think you can trust, that you can make trustee of your trust, who will still take care of you and make sure that you're adequately seen to all your needs while you're still alive, but then protect your assets moving forward. So that would be my first recommendation. The second thing that you can try and do is, here's another problem that comes up. You get all the proper advice you need for your trust and your will planning, but then you don't necessarily carry through with what you need to do to create that trust. So here's an example would be, you've got this will that says everything's going to go into a trust, and the trust is going to distribute the money to children A, B, and C in this capacity. But then you put the bank accounts in the name of you and one of the kids as with rights of survivorship. Well, guess what? That stuff isn't going to the trust anymore. And this is one of the personal situations that I ran into. When my mom passed, there wasn't a question that somebody had changed her will or something, but she hadn't put her assets into the right vehicle. And so it took me 6 months of chasing stuff down and then recreating what I knew she wanted to do that was in the trust, but it wasn't left that way. It was left to her and one or the other of her kids with rights of survivorship. So I had to essentially rob Peter to pay Paul, if you will, to make sure that everything in the end worked out with the instruction that I knew she wanted, which was the subject of her trust. But it took a while to get there, and it had to deal with a lot of issues with banks that I otherwise wouldn't have to deal with. And a less scrupulous trustee or a less scrupulous kid might not have done that. And they might have said, oh, well, it's all very well and good. That was her intent, to split everything up in thirds, but she left that account to me. So tough luck, guys.
Exactly. And as you said earlier, when money gets involved in things, sometimes that can change dynamics significantly.
Yeah,
absolutely. Well, we are coming up on about 30 minutes, and I promised you, I know you've been exceptionally busy lately. I promised I wouldn't keep you for too long, but I do have an ask, and that ask is, will you hopefully come back and talk with us again someday very soon? I'm sure we're going to have a ton of questions, people wanting to speak with you again. Would you be up for that?
absolutely. Absolutely.
Okay, amazing. Now, for those of you who are listening or watching, You also can actually reach out to him directly. Please, Ron, go ahead and share how they can reach out to you if they're coming up on the situation, experiences in the situation. Hopefully you heed his advice and you won't. But if you are in the situation and you need some litigation help and advice, how can they connect with you?
So you can look me up in the Florida bar, or I'll give you my email address. It's rschirtzer, SCHIRTZER, at wwhgd.com.
Perfect. All right, guys. So you have it right there. You have direct connection to Ron if you need some help. He's given us just a taste of his knowledge here today. So if you want more of that, be sure to reach out to him. And if you want more of me and this podcast, be sure to tune in for next time. Until then, I'm Tanisha Coffey with Rock Solid Financial. Thanks so much for joining us today.
Thank you, Tanisha.
You've been listening to the Legacy Leaders Podcast with Katie Beth Hand and Stan Miller. For more information on them and the show, please visit pinnaclelegacylaw.com. If you like what you've learned today, do share the program with your friends and subscribe wherever podcasts are found.